Good morning, guys. My name is Shiven Asthana. I am a second year law student from WIPS IP Delhi and an intern at LEXIS and Company. So, today I'll be talking about the topic negligence. Negligence, it is a failure to exercise appropriate and or ethical ruled care expected to be exercised among specific circumstances. The area of tort law known as negligence involves harm caused by failing of an act to as a form of carelessness, possibly with extenuating circumstances. So, under negligence, there comes duty of care. The idea of duty of care in the tort of negligence has developed through judges making decisions in cases. This started in negligence cases of Donog versus Stevenson, where the claimant, Mrs. Donog, went to a cafe with a friend. The friend bought her a drink of a ginger beer and ice cream. The bottle of ginger beer had dark glass so that content could not be seen. After drinking some of it, Mrs. Donog poured the rest of and then saw it contained a dead snail and it was decomposing. The appalled Mrs. Donog and she became ill as a result of the sight and the ginger beer she had already drunk. Mrs. Donog had no direct claim against the manufacturer or the shopkeeper based on the contract because she did not buy the ginger beer. Mrs. Donog's friend could claim against the cafe but she had not suffered any loss apart from the fact that she had bought defective goods. She could get her money back but nothing to Mrs. Donog's illness. Therefore, Mrs. Donog claimed damages against the manufacturer Stevenson. Her claim was for the resulting shock and stomach upset which was claimed by through drinking the ginger beer. The court had to decide whether her claim against the manufacturer of the ginger beer could succeed. This led to Lord Atkin's famous statement, the rule that you are to love your neighbor becomes in law. You must not injure your neighbor, and the lawyer's question, who is my neighbor, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I thought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called an action. Donog vs. Stevenson in the case of 1932 was the first successful attempt to set out a general principle with respect to the concept of duty of care. How, as lawyers realized this principle could be manipulated to be used with different types of situations, the test was reformed to form the three-part test in the case of Caparo vs. Dickman. The general test in Caparo requires three elements. It was reasonably foreseeable that a person in the claimant's position would be injured. Second, there was sufficient proximity between the parties. Third, it is fair, just and reasonable to impose liability on the defendant. All parts of the test must be satisfied if there is duty of care owed by the defendant of the claimant. Each part must be explained and proved separately. So, breach of duty. Once a claimant has proved the duty of care is owed, he must then show that the defendant breached that duty. This is merely when the defendant falls below the standard of care appropriate to the duty. Breach of duty is measured objectively by the reasonable man test. The reasonable man is the ordinary person performing the particular task. He is expected to perform it reasonably competently. For a breach of duty to occur, the court will take four factors into account. In some situations, it is difficult to know exactly what happened, although it is found obvious that the defendant was negligent. In these situations, a rule called res ipsa loquitur, which means thing speaks for itself, was developed by judges. It has to be shown that the defendant was in control of the situation. The injury was more likely than not to be caused by negligence. If the claimant proves these two things, then the defendant has to prove that he was not negligent. This rule was shown in the case of Scott versus London and Saint Catherine Docks, where the claimant was hit by 6 bags of sugar which fell from the defendant's fare house. The claimant could not say why the bags had fallen, but the court ruled that the facts spoke for themselves, and it was for defendant to prove that he was not negligent. Damage caused. Second aspect. Having established a duty of care and a breach of that duty, the claimant will then need to show that damage has been caused to them and that loss is not too remote. A person will only be liable for damage which they have actually caused the victim. The same rules apply to damage of property. Causation, but for test. Would the damage have happened if there was no breach of duty? This can be seen in Barnet vs Chelsea and Kennington hospitals, where 3 night watchmen went to accident and emergency complaining of sickness after drinking tea made by the fourth man. This meant that his death was not a result of a doctor's breach of duty, so the claim failed. So basically what happened is there were a sickness after a nurse telephoned a doctor on duty who did not come to examine the men but instead sent the men home and told them to go back and see their own doctors in the morning. On returning home, one of the men died a few hours later from poisoning. His widow sued the hospital, claiming the doctor was negligent in not examining her husband. Evidence show that by the time the husband had called into the hospital, it was already too late to save his life. This meant that the death was not a result of the doctor's breach of duty, and so the claim failed. Foreseeability, the last aspect. The claimant has to show that type of damage was reasonably foreseeable. This is the scene case of the Wagon Mound, 1961, where fuel had negligently spilled out onto water in a harbour. 2 days later, the oil caught fire because of welding work being done under the ship. The fire spread to the claimant's wharf and burnt it. The damage suffered was not reasonably foreseeable. So in this test, it failed. So these were the aspects related to negligence and what was negligence. Thank you.